The question of litigation following a recall really comes down to two factors in my view. The first is the ongoing relationship between the manufacturer and those further down the supply chain, and indeed those up the supply chain, and whether or not there is space for that ongoing commercial relationship. Put simply, if you start suing your client, they're unlikely to be your client on a continuing basis. The second is also the presence or otherwise of insurance, and product recall insurance in particular. There you find that there may in fact be other interests that are at play where the parties insured recovers under their insurance policy, and then the insurer has some rights which can sometimes lead to litigation, notwithstanding the desires on the part of the manufacturer. When it comes to the types of claims that you see from product recall events, I'd probably put those into two categories. The first, if you like, is relating to the first-party losses that the relevant manufacturer or supplier ends up having to meet. So they will be obviously their crisis management, their consultants, the cost of actually recalling the product in the first place. And their, say, first party, the cost that they themselves have to absorb that can then form part of the claim. And the second is obviously something which achieves considerable more press, and that is the third-party losses, the third-party damages that one can see. Obviously, physical injury is one of them, one of the key issues. Latent and unforeseen continuing losses, loss of profits by those who have suffered downstream, and it is a characterisation between those first party and third party. Invariably, the third party losses are the ones that garner more press and often the bigger numbers. In my view, there are four things that they should contemplate. And very briefly, they are have in place a crisis management policy in the very first place to ensure that they know what to do when this thing arises for the first time. The second thing is to consider and receive advice on their obligations to regulators, because it's often the case that some sort of regulatory intervention ultimately leads to litigation. So the manner in which you interact with the regulators is of critical importance. The third thing is to have one eye on the possible defences as one goes through the crisis management plan and executes various parts of it, and thinking what interaction and what consequences of that might be downstream. And the fourth one is pretty simple really, but is often forgotten, is to make sure that decisions made are properly documented. The things that companies need to think carefully about is how they deal with their PR and communication when an event arises. And views can often differ even at board level as to how that should be approached. Depending on the size of the company, there may be your own communications area that can advise on as things progress. But put simply, it's often in the interests of the company, or perceived to be in the interests of the company, once a recall, the step of taking a recall has been decided, to effectively make a series of admissions in order to mollify people who are disgruntled. That can sometimes and often is the best way, but not always. Directors and officers very much have a role to play in consideration of product recall. At this simple level, part of their job is to foresee difficulties which the company with that particular business could potentially suffer. Now, they're not obliged to consider every possible eventuality, but if you're in manufacturing or supply, then product recall is one of the key exposures your business faces. So at the very least, directors and officers must work closely with their insurance brokers and their other advisors to ensure that they're aware of what policies are out there and that they're making an informed decision on what they should be taking up.